Let's talk about the 3 things that you need to do if you want to see all of the evidence against you in a criminal case. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, this video is about the 3 things that you or your lawyer need to do if you want to see all of the evidence against you in a criminal case. So number 1 is that your lawyer needs to look at the police report and figure out what is missing that they don't have. And let me go back. Okay, so this process is going to sound really stupid, and that's because it is. At least in all of the counties that I have litigated in California, which include Sacramento, Ventura, Kern, San Diego, Orange, Riverside, San Bernardino, and Los Angeles. That is 8 counties. In all of these counties, at the very first court date, all that you get, your lawyer gets, is a copy of the police report. So maybe there's surveillance video. Maybe there is body-worn video that the cops took. That is not handed over to your lawyer. So you would think, especially if you're in jail or you had to pay thousands of dollars to get out, now you had to hire an attorney for the case, you would think that they would have this whole stack of evidence against you that they obviously looked at when figuring out, should we arrest you, should we keep you in jail, and they should hand it over to your lawyer at the first court date, right? I mean, that is how it should work, but that's not how it works. We just get the police report most of the time, sometimes some photos, but most of the time we don't actually get everything, even if the client is in jail. So the first thing that your lawyer needs to do is look at the police report, and sometimes it will say in there, we review the surveillance video from the corner 7-Eleven, and here is what we saw on that surveillance video. And obviously, we're not going to rely on the cop's interpretation of what was on that surveillance video. We need our own copy. Another thing that is really common is, the cops have body-worn cameras, and they'll say, BWC were activated during this incident. Okay, well, we need that because many times when they are interviewing the witnesses, this is the video that shows us what exactly the witness said. We're not going to rely upon the summary that the cop wrote down 2 or 3 days later in the police report. We need to see it for ourselves. So those are 2 common examples, but sometimes, even photos, medical records, they'll be mentioned in the report, but we will not have it. 911 call, that's another big one that's mentioned, but we need to actually request it. So your lawyer needs to be on top of that and make sure to request all of the evidence. Number 2 is that your lawyer has to use their knowledge and their experience and frankly their common sense to figure out, okay, what probably exists that's not mentioned in the police report. So many times it will not say anything about body-worn video, but maybe most of the cops in LA County do have body-worn video, or maybe they say that there's a confession. Okay, well, most of the time there's a recording of that. So your lawyer needs to use their knowledge and experience to figure out what else might exist and request it. And then get a statement, either it exists and here it is, or it does not exist at all. You need confirmation either way, not to just have it hanging out there. And by the way, there are only 3. I've already committed to only 3 reasons here or things that you need to do. But if you were in jail and your lawyer says, hey, we're waiting on the discovery, let's waive time, we'll come back, next month. No. If you are sitting in jail, okay, if you're sitting there in jail, absolutely miserable, right? Jail sucks. Why would you give the prosecutor more time to gather the evidence/discovery? That's what it's called in the system. I mean, what the prosecutor will say is, I have to email the cops, and the cops have to request it. It's this whole process. That's not your problem. If you're in jail, that is not your problem. If the prosecutor has to stay a little bit extra that day, work a little bit extra for their salary, who cares? That's not your problem. You are in jail. So you shouldn't be waiving time for that. Your lawyer should not be telling you should waive time for that. Of course, prosecutors hate it when you say, no, I'm not going to waive time to get that discovery. But your lawyer shouldn't frame it in a way with the prosecutor that it affects you negatively. The lawyer should say, how can I do that? How can I advise my client to waive time? They're in jail and we don't even have all the evidence. So, sorry, dude, but No, I mean, I need it. Like, we're going to come back next week and I need it then. I need it by then. And the lawyer should also let the judge know what's going on, because otherwise it will take forever. They will take forever. They will procrastinate in getting you this discovery. And meanwhile, you're sitting there miserable in jail, right? Maybe you didn't even do anything wrong and you're sitting there miserable in jail. Sometimes attorneys, because of their own scheduling reasons, will try to have you just sit there and waive time and wait for this discovery. No, you don't have to do it. Don't do it. Don't agree to that. And if your lawyer is saying that, you probably need a different attorney. Number 3 on that note is that you need an attorney who is willing to give you copies of the evidence. I know that this sounds stupid too, but a lot of people who call me that have an active case, they've already been to court a few times, I'll ask them, hey, do you have a copy of the police report? Because if you do, I want to look at it, right? Most of the time they won't have it, and they'll say, no, like I wasn't allowed to get it. My public defender said I couldn't have it. Okay, look. The only reason that you wouldn't be able to have a copy of the police report or other evidence is if there's a protective order in place that the judge agreed to. And this is usually in like gang cases. So it's not that common. If it's just like a domestic violence case, very unlikely that this existed, and you would hear it in open court. But you can also ask your lawyer if there is one. The protective order would bar you from having copies of the discovery, but that's rare. It's like gang murder cases. The real reason why they don't want to give you a copy is because it is kind of a pain to give you copies of like the written discovery, because we have to black out certain information on it. Of course, like that, it doesn't take all that long, but for public defenders that are super slammed, of course, they're not going to want to do that in every single case. But most private attorneys, you should have your paralegal already set up to automatically just go ahead, redact it, and give the client a copy. Sometimes it's not possible with videos, just depending on the file type. Some surveillance videos, they're this weird, like it's actually like an exe file and you need the original. In that case, we can show the client at court or in the office or something. But it is important, of course, that you're able to see. What if there's surveillance video and you watch it and you're like, wait, that's not me? I mean, that's really important, right? It sounds so stupid. A lot of this stuff sounds so stupid. And when I first started doing this, I just thought, how the heck can this be the system? But it is. And it's important for you, if you have a criminal case in California, to understand this and know this. I hope that you found this video helpful. If you do have a criminal case in Los Angeles, feel free to give me a call or book a consultation. My number and the link to book a consultation with me are both down below.